My name is Charles Gallagher. Welcome to today's G&A Foreclosure Minute. Today's topic has to do with a very dangerous piece of proposed legislation submitted by the Florida Bankers Lobby. The act entitled Florida Fair Foreclosure Act of 2012 has been drafted and prepared and submitted for sponsorship in Tallahassee. The act itself provides for many problems with regard to foreclosures in the state of Florida. It proposes to accelerate the process of foreclosures in Florida and the courts, remove some from the courts altogether, and otherwise waive and abolish many defenses that homeowners currently have under Florida law. Some of the provisions that are most concerning are as follows. First, the provisions of the Act purport to provide for attorney's fees in the event the lender wins the case. Presently now, there is no such right to attorney's fees if a lender prevails in a foreclosure. Secondly, the Act purports to increase the time frames and speed up the process. Where the foreclosure is not contested, the Act purports to require a judgment within 45 days of the pleadings being closed. And that is rapid fast compared to the current time frames now with the court dockets. The next provision, which is very concerning, has to do with the abolishing of Florida Statute 57105. That statute prevents from frivolous claims being filed by attorneys in the state courts of Florida. In the event an attorney files a frivolous claim and the opposing party will put them on notice, they can be sanctioned with attorney's fees. However, here the Act purports to abolish that in entirety for reasons that are related to the likely prosecution of foreclosures where a party does not have standing, such that the lender now has no possible liability for attorney's fees in the event of a wrongful foreclosure being filed. Another problem in the Act has to do with the automatic return of the promissory note at the end of the lawsuit. This allows the borrower to be subject to a deficiency judgment much quicker than it would be if the court had required an order to remove that note from the court file after the fact. Two other issues that are very concerning have to do with post-foreclosure issues on wrongful foreclosures. The first issue has a limitation to the challenge of a wrongfully filed foreclosure. Presently now there is ability to go ahead and seek an injunctive relief with regard to a wrongful foreclosure. However, the Act as drafted would remove that and only allow a party to proceed with monetary damages. The final problem with the Act, one of the final problems with the Act, has to do with the issue of lost and misplaced documents. Many times now in the foreclosures, parties will lose assignments and affidavits, transfers, and rely upon a lost document. Well, currently Florida law requires that somebody reestablish those with knowledge of the loss at a certain time when they actually had possession of it. Now, the Act would then prohibit anybody from making a claim upon a property where a lost document was used as the basis for a foreclosure. So we've got a number of rights being waived and abolished that Florida homeowners already have right now. If you have a problem with this Act or would like to go ahead and advise your congressman of your objection to these terms, please feel free to go ahead and write your congressman an email or letter. You can go ahead and find out your representative on www.myfloridahouse.gov. Put in your name, put in your address and zip code. It will give you whose local state reps are in your district, and you can write them a letter accordingly. If you have any questions regarding this Act, this dangerous Act, please feel free to call us here at Gallagher & Associates, 727-344-5297, or visit us on the web at www.attorneyoffices.org. Thanks a lot and good luck.